good morning, good afternoon, or good evening, depending on wherever you are. On behalf of North-South University Law Department, it is my utmost pleasure to welcome you all to this webinar by Professor Thomas Schultz. He will speak on change in international law, the temporalities of marketplace. And before we hear from Professor Schultz, I formally invite my department chair and my esteemed colleague, Barrister Arafat Hosen Khan. Arafat, over to you.
Thank you, sir. Thank you, sir, for arranging this webinar, and also thank you for inviting me to say a few words on this. I'm very, very happy to be at this webinar tonight. It's tonight for us. So, ladies and gentlemen, esteemed colleague, distinguished guest, very good evening from Bangladesh, and I think it's good afternoon for our distinguished speaker, right?
Yes.
And like, probably good morning if someone from other part of the world. It is with a very great pleasure and enthusiasm that I welcome you to this webinar on dynamics of international legal changes, emotion and market opportunities for ideas, hosted by Department of Law at the North-South University. We are very honored to present a thought-provoking session led by Professor Thomas, who is a professor of law and associate director of the Center for International Governance and Dispute Resolution at King's College London. As someone who was fortunate to pursue studies at King's College London with the prestigious evening scholarship, I'm excited to join this insightful exploration of the intricate interplay between emotion and market opportunities in shaping international legal evolution. Our distinguished speaker's expertise promise to shed light on the nuanced dimension of this subject matter, fostering meaningful dialogue and enriching our understanding of the global landscape. I welcome everyone to enjoy and get engaged, and thank you all for joining on this enlightening journey for intellectual exchange hosted by NSU Law. Thank you all.
Thank you, Arafat, for your remarks. Professor Schultz, over to you. Thank you.
Thank you very much for having me. It's a wonderful pleasure to be here. Before I get going, I should say that I will speak for 45 to 50 minutes, so it's going to be quite long. And the paper I'm going to deliver is, in parts, a bit dense. The good news is that it isn't really one argument which builds from A to Z, so that if you miss D, F, or Q, you miss the overall point. It's rather a concatenation of points. So if you have enough of me at any juncture, you won't miss much if you space out for a bit and do something else, because the next points you should be able to understand independently of what came before. We probably all want international law to change. There's hope in change. We tend to want progress because we are lawyers. We may well believe that international law may help us achieve that progress. And so, as scholars, as academics, we write. We write in the hope that we can make international law change. We try to contribute to its understanding so that others will realize what is going on and may use that understanding to bring about change. We try to contribute to building the technology that international law is so that others can use it to achieve things. As citizens, not in our professional capacity then, we probably hope that the powers that be will take international law somewhere, perhaps just forward, perhaps sideways, to help a bit with the human condition and the state of the world. Change, international legal change, is something we have reasons to be curious about. After all, much of what we do in this life seeks to either usher us in something different, something changed, or precisely to prevent that from happening. So how does that work? What stands in our way? What helps us? What are the dynamics of it all? When and how does international law change? A legal formalist and many textbooks would like to respond that it is all clear, would respond in the register of the forms of the law. Just like some economists would say, it's the economy stupid. The legal formalist might say it's the texts stupid. All depends on black letter law. Read the rules, and you will find time references which give you the temporalities of international legal change. Read the secondary rules of change in H.L.A. Hart's sense. And then the discussion turns to state practice and the formation of customary rules. Attention is drawn to sunset and survival and grandfathering clauses, to cool-off periods for international dispute settlement, to stabilization clauses in international investment agreements. Scrutiny is directed to relevant dates for state succession, to ratione temporis considerations for matters of applicability and jurisdiction, to sundry rules of international legal procedure with references to critical dates and time limits. A modern legal positivist, that is someone trained in legal positivism after the Hartful debate of 1958, would say, wait, Hart's secondary rules of recognition, change, and sanction are actually matters of social facts. International legal change is very much an affair of societal and institutional practices about legal norms, an affair which takes us to the different practices surrounding international law in quite different sites. Observe these practices, these social facts, not just the texts, and you will see the temporalities and the dynamics of international legal change. Nico Krish recently observed these practices and saw 5 paths of change in international law. When states change their behavior, when states issue statements within IOs, international organizations, when IOs make decisions without the direct participation of states, when courts make decisions, and when private recognized authorities produce technical manuals, standards, regulations. That, he points out, is when and where international law really changes. These are the real sites of change. The secondary rules of change as text matter much less than we think, he says. So we have the formal rules and the social practices surrounding these rules. We have the law on the books, understood by looking at texts, and the living law, understood by looking at the facts of how people and institutions behave. Okay. Now, someone like Mark Blyth, a political scientist interested in institutional change, might say, aha, and the thinking? Formal rules and the social practice of these rules are crucial structuring factors of change, yes. But if you take a step back and look at international law as an institution, by which he means a regime, a whole thing, for that to really change and find a new equilibrium, the rules and social practices don't explain it. New thinking, new ideas, he says, need to occur, and the time must be ripe for the translation of these ideational changes into institutional changes. So new thinking, and then when the time is right, the thinking changes reality, translates into institutional change. Now, the right time for that translation, Mark Blyth argues, are typically periods of crisis and marked uncertainty, like now, arguably. On the conditions of great uncertainty, Mark Blyth explains, the politics of ideas become increasingly important because ideas make institutional construction possible, like now, arguably. So ideas evolve at their own pace and then push and shove reality at specific times, specific junctures, which might be called, for want of a more charming word, ideational institutional translation junctures. Bad word anyway. So the politics of ideas would be important, and they would be important now. By politics of ideas, he means in essence, when and how ideas, the thinking, when and how do they change? Here, a legal theorist interested in the surrounding material circumstances of international law might say that it all depends on the overall economic and political conditions of the times. The overall economic and political conditions of the times, of our times, influence what ideas, what thinking is acceptable and finds traction. Some have argued that this is bad news because the core of the economic and political conditions of our times is bourgeois conditions. And the bourgeois conditions have led us to believe that progress the way to go is straight ahead. More of the same, more economic growth, more international legal rules, more international courts and tribunals, more law, more of the same. At the heart of it is a linear approach to time. Progress is always ahead, further down the same road, regardless of past failures on that road. This hampers serious questioning and thinking. Just keep going is the mantra. Persistence is good. Just keeping going is good, but questioning and thinking are important too. These surrounding material circumstances of international, these overall economic and political conditions of the times, they influence the ideas and the thinking in the field. But they do not determine them. They're not the sole determinants of the thinking in international law. They're not the sole drivers of the ideational dynamics of what we do, if what we do is think. There are many other determinants of how we think, and, I repeat, now may be a good time to understand what influences how we think, because the politics of ideas, as Mark Blyth would put it, the how and why of their change, they seem particularly important now. Among these other determinants, what I am interested in, at least today, is something below, something less grandiose than the overall economic and political conditions of our time, something more mundane. I'm interested in how our emotions influence how we think about international law, how emotions influence how we perceive it, understand it, write about it, try to reconstruct it in our heads, in our cosmogony. In other words, how our emotions influence our epistemology of international law. And I'm interested also in market opportunities for ideas, and when these opportunities arise, leading to the reception of ideas in the field. Perhaps two quotes by Pierre Schlag, the American legal theorist, the charismatic bad boy of American legal academia, might help understand what this is all about. Here goes the first. I quote, Robert Gordon once said famously, "Things could be otherwise." This was the heyday of social constructionism. For Robert Gordon's generation, the realization that law is socially constructed felt liberatory. They had been schooled in an orthodoxy that presented law as objective and neutral. If objectivity and neutrality were the incontestable baselines, social construction must have seemed like freedom itself. For my generation, Pierre Schlag continues, socially constructed meant something entirely different. It meant that things were really, really hard to change. The question of how you do that was, for us, still Schlag, was not clear at all. It is and remains an interesting question. End of quote. Things could be otherwise. Thought things could be otherwise. How we think about international law, how we apprehend it, how we mentally reconstruct it, what we make of it at the level of ideas, then re-inject it in the world of facts, that could be different. Ideas are socially constructed, obviously. Ideas about international law are socially constructed. Now, the problem with that, with ideas and their social construction, Pierre Schlag continues, is that, I quote him again, ideas are very hard to come by. They require struggle, not only against the various orthodoxies that compose the university, but a struggle against the various social and political inertias and momentums that comprise and quietly maintain these orthodoxies. Many of these inertias and momentums arrive innocently enough, bearing names such as research agenda, faculty workshop, conference panel, law review article, and so on. End of quote. To put this bluntly, what I'm after is why it feels so difficult to be original, to truly think outside the box, to really have and offer ideas for international law. In particular now, when it seems to matter, now that we seem to be at an ideational, institutional translation juncture, to use that ugly word. Why are we so boring most of the time? What are we really after emotionally? Because that's what mostly drives us. And how does the market for ideas constrain or orient us? These are simple questions, and I'll try to offer simple answers. So let me turn to emotions. There hasn't been all that much work on emotions and international law, but there has been some. That work has dealt with the role of emotions in the making of international law. For instance, how fear influences treaty making in a study by Andrea Bianchi and Saab. It has also dealt with the use of emotions in the rhetoric of international law. For instance, again, in a study by Saab, how the climate change discourse mobilizes anxiety, knowingly or unknowingly, to advance its agenda. Emily Kidd-White has done work on the role of emotions in structuring the object of international law, separate from the subject studying it. She argues that rational classical approaches to international law puts the focus on contingency, treaties, ownership, jurisdiction, while an approach grounded in emotions would see bodies, precarity, relations, desires. That's all good, but that's not what I'd like to focus on. What I'd like to focus on is the subject studying international law and what emotions likely traverse him or her, not the emotional objects he or she studies, like precarity, terror, but the emotions of the subject himself or herself. The two, the object and the subject, are of course co-constructed, dialectically linked, but that's another matter and doesn't change my argument. It's also not, what I'd like to focus on is also not the emotions of the people for whom international law is made. That's not what I have in mind. As in the idea of making law to reassure people that something is being done, or playing their emotions to get an agenda through. I'd like to focus on why emotionally we do the ideational construction of international law that we do, what emotions influence our epistemologies, and thus the manufacture of our scholarship. It's somewhat close to what Martha Nussbaum has done when she writes that emotions must, I quote, form part of our system of ethical reasoning, and we must be prepared to grapple with the messy material of grief and love, anger and fear, and in so doing to learn what roles these tumultuous experiences play in our thinking about the good and the just. End of quote. The difference, though, is that the difference between what I try to do and what Martha Nussbaum has done is that she focuses on ethics and on emotions as judgment, and I try to focus on legal epistemology. Even though I understand there may be an overlap between the two, epistemology is a form of judgment because the knowledge act, the decision to know, is a form of judgment. As someone else put it, perception makes us see the world, understanding makes us know the world, emotions color the world. Color here means to attribute importance to something, which is an act of judgment, possibly an act of judgment of what we decide is important enough to form part of knowledge. It's fairly close what I try to do to Pierre Schlag's aesthetics of law, aesthetics in the sense of the principles underlying one's work, not in the sense of beauty, though they are linked the two. But with a specific, what I try to do is close to Pierre Schlag's aesthetic of law, but with a specific interest in the emotional raison d'etre of these aesthetics. In other words, why the specific principles that underlie our work? Why emotionally? Brutally simplified, what emotions are likely to influence us, scholars, when we do what we do, when we produce scholarship? What are we psychologically after when we do that part of our job? Because this in turn influences the scholarship that we have in the field, which in turn influences the international law that there is and its dynamics of change. As I've mentioned, international law evolves also according to turns in thinking, according to developments in how we think about it. And these turns in thinking are partly due to, or precisely prevented by, what drives us individually when we do our job. And what drives us is no doubt partly and probably largely our emotions and what we are psychologically after. So if we are more self-reflexive, if we gain a deeper understanding of who we are and why we do what we do, we may make clearer choices about what we really want to achieve with our work, and thus what kind of international law we contribute to making. Some might call this a psychologically self-reflexive approach. Others have called it a Buddhist approach to international legal epistemology. Some of the main emotional drivers of why we do what we do when we do scholarship, I argue, are the fear of death, the fear of exclusion and the need to belong, the need for recognition, the need to work hard, the sense of moral superiority of the international lawyer, and the pleasure, number 6, of finding things out, fun. Let me take them in turn. So the fear of death. You may have heard of the cultural phenomenon book, The Denial of Death by Ernest Becker. In his post-Freudian work on psychoanalysis, he argues that most human action is taken to ignore or avoid the inevitability of death. Becker says that, I quote, man's innate and all-encompassing fear of death drives him to attempt to transcend death through culturally standardized systems and symbols. End of quote. We usually wear character armors to deny that fear, he finds, and they mask and obscure self-knowledge, leading us to do silly things. He would go all the way to argue that much of the evil in the world comes from the need to deny death, including the invasion of neighboring countries for the sake of transcendental historical continuity. As part of that overall human reaction to the fear of death, at a more mundane level, there is simply a need for certainty and control. We cannot control death, but we would very, very much like to. So we try to project that need for control onto something else. The uncontrollable nature of death leaves anxieties which are coped with by thrusting that unmet need for control and certainty onto what can be controlled or what we think can be controlled. And this may take the form of obsessively cleaning things, obsessively ordering things, or indeed obsessively ordering thoughts or the world as reconstructed in our heads. The fear of death, arguably, when applied to the epistemic manufacture of scholarship, leads to binary, Manichaean right-wrong approaches, clear demarcation lines, well-marked boundaries, neat separations of concept, the creation of form objects in the thinking about law. These form objects in the thinking about law are, like most objects, delimited, fixed, and substantial, resulting in what Pierre Schlag famously called the grid aesthetic, where everything is neatly arranged on a grid, each rule or concept sitting properly next to the other, no overlap, no gap. The grid, as Schlag puts it, feels, I quote, solid, reassuring, determined. End of quote. Psychologists find it completely unsurprising that if we don't realize what we are doing and let our fear of death take control of our work as scholars, then we engage in excessively rigid thinking, excessively rigid legal formalism, for instance. We try to reconstruct in our heads a representation of international law which is conceptually and normatively controlled, normatively here in the sense of what relates to norms simply. A representation in which each concept or norm or rule has its proper place and is clearly defined. That's not necessarily a problem. It has certain advantages. This may be a problem if what we say and believe we want is international legal change, but in reality, without knowing it unconsciously, what we are after is alleviating our fear of death. And that means to freeze up or do something tangential. We think we do something for a reason, but in reality, because we don't know ourselves well enough, we do it for a different reason, which we could let go of or deal with differently, allowing us to get done what we consciously want to get done. Now, invading a country for the unconscious purpose of denying the fear of death is, of course, quite a bit worse than producing overly formulaic, rigid, and unimaginative international legal scholarship, but the underlying psychological process may not be so different. When I say what I just said to psychologists, they mostly shrug, say, yes, that's obvious, and they wait until I'll actually have something to say. When I say it to lawyers, they mostly look back at me with a look that combines incredulity. What the heck is this guy talking about? Or pity. Poor guy, he must have a problem with death. Or quiet anger, which is the most interesting. This is nonsense, they say. I just want to get through the day, they say. I just want to get things done, they say. And God knows I don't want to go deep into my soul. I'm afraid of what's there. So just stop. That last bit they don't quite say, but it's quite obvious that this is what they think or feel. Emotion number 2, the fear of exclusion and the need to belong. We are social animals. On our own individually, we are exposed. A long time ago, we would have been eaten by lions. Later on, we'd mostly just be starving. We have a biological DNA encoded need to belong because those who did survived. Social rejection has been shown by people putting other people in scanners. Social rejection has been shown to be encoded by the brain the same way it encodes physical pain. When we say that social rejection hurts, we speak neurophysiology. It's actually not a figure of speech. For many psychologists, social rejection is one of the worst things you can do to a human being. In the long run, if done repeatedly, it can lead to all sorts of very serious mental illnesses. Repeated social failure, you want and try to belong, you are rejected, leaves more psychological scars than many forms of torture. So what? Well, so when we do international legal scholarship, we don't want to be rejected too. I don't only mean not getting a job for young people, but just being socially rejected is bad enough. This fear leads to epistemological mimicry or epistemologically blinding loyalty to the group one wants to belong to. You probably have heard of the flat earthers, those people who say the earth is flat. Now, many of them say this. Now that I say the earth is flat, I have found friends. I'm no longer alone. Some add, what do I care whether the earth is really flat or round? I care about that community, about these friends, about not being alone. That's exchanging truth for company, epistemological sense for social belonging. It may not be such a bad idea after all. We do that kind of thing all the time, in fact, not that blatantly. This need to belong also leads to mimetic desires, which Paul Ricoeur famously examined in detail. Mimetic desires are the idea that your desires and mine are copied of other people's desires. If others want something, you and I will want it too. You and I will copy their wants, their desires, because what we really want is belong to the group, and have the same desires helps belong. So this need to belong leads to mimetic desires in assessing or self-assessing scholarship. They want that, so I want it too, even if it makes no sense in itself, and I will steer my scholarship in that direction. For a long time, things have started to get better. For a long time, international law as a scholarly field was a relatively uniform and cohesive field. People would speak the same intellectual language, would understand one another, and would find it great. But it also meant that they inhibited one another's thinking by creating one main epistemological mimetic desire, one way of thinking. Bluntly put, everyone had to think alike to be part of the group. Those who thought differently simply disappeared. When an epistemologically self-referential group understands international law for a polymorphous society, that's bad for democracy. Now, if you wonder where so much of the mechanically reproducible, instantly forgettable scholarship one finds in the field comes from, this may be one of the answers that psychologists will give you. If we don't consciously understand what we really want, that what we really want is belong, that we act out of fear of rejection, we pass over many freedoms in our thinking. We pass over these freedoms because this need to belong can be achieved by other means than aligning the thinking. Emotion number 3, the need for recognition. The drug of applause, of citations, of invitations to red carpeted places, even if the red carpet is an imagined image on Zoom. Yes, being invited for today felt good. If we were in a real room and if you clapped at the end out of habit, it would feel good. When it first happens, you smell blood, and then you want it again and again. For some, it is the best thing in the world. Finally, I am someone. The nerds among us, the round pegs in the square holes, those who didn't fit in when we were young and grew up feeling inadequate. Finally, this is over. Finally, I am someone. So what do I need to do it? What do I need to do for it to happen again? I'll do anything to feel it again. Just tell me what to do. Well, publish a lot. Engage in full-blown scholarly productive production overdrive. Be everywhere. Get your name around. Elbow others aside. Kill them if need be. Cut corners in your scholarship. Filter your own views and findings if they don't help you. Lie if it helps. Misconstrue facts, understanding, citations. As the famous movie line goes, I'd rather be a fake somebody than a real nobody. I'm not making this whole thing up. I'm exaggerating a bit to try to bring the point closer to home. Bruno Latour showed how much all of this was happening in the natural sciences, how scientists filter the truth, often unconsciously, so that they can shine. Scientists are human beings, and so are we. And then the trading truthfulness and honesty for a fleeting moment in the spotlight that leads to feelings of guilt, remorse, regret. So you need to compensate that to feel good again. What makes you feel good? Ah, yes, the spotlight, recognition, applause. And so you try to succeed yourself out of your real questions. But in doing that, you also succeed yourself out of what you said you wanted. Change international law to change the world. Emotion number 4, the need to work hard. It's not technically an emotion, but the technical difference between emotions and other neighboring psychological drivers doesn't change my point. I mean the moral elevation of hard work for its own sake. Who has never said or heard that this or that piece of scholarship is an impressive effort? Who has never assessed a colleague on the basis that he or she works hard, think that this is obviously good? But why? Why is hard work an independent quality, an unconditional positive? If I work hard and have no ideas, am I really better than you if you barely work but have strings of great ideas? I don't think so. Anthropologists would suggest that the reason why we have come to value hard work for the sake of hard work comes from primitive ancient societies. It would appear that hardworking individuals have a general tendency to be more cooperative. So if you need cooperation and had no sophisticated culture to determine who can reliably provide it, you use a proxy. That proxy is hard work. So hard work is not good in itself, but it's a way to increase your chances of obtaining collaboration. And that is good in itself because collaboration increases chances of survival. As legal academics, we probably have also been contaminated with some of the timesheets obsession from our friends in law firms. Ah, the timesheet gods, for whom more work is always better because it translates with absolute certainty into gain. The fear of the advocate of being tripped up in court by an opposition in litigation, which means professional harm to the lawyer and other harm to the client. That too likely explains the lawyer's overall drive for hard work. But it may stand in the way of all of us who are supposed to maximize thinking and ideas, not work. This need for hard work leads to oceans of footnotes, to summaries again and again of the existing literature. This in turn makes ideas yet more expensive because you need to jump many hurdles before you can dare to voice an idea. A typical discussion would go like this. Oh, your article. Yes. You have a good idea, but you really need to reference it more. Ah, thanks. But would the references change anything to my idea? Oh, no. But just having ideas is not work. You can't do that. This discussion I'm actually not making up. Tedious, too much information. Find the idea in the haystack scholarship. That follows from all that, all of which adds momentums and inertias, which maintain the orthodoxies, which in turn prevents progress and change. Emotion number 5. I'll be brief about this one and the last one. The sense of moral superiority of the international lawyer over the domestic one. This would be fueled by a sense that we tell states what to do, and we stand above in the formal hierarchy of norms in most countries. This is not good for progress and international legal change because in our self-importance, we tend to neglect domestic legal thoughts and domestic methodologies. And we need to reinvent so much in international law, which has long been in existence in domestic law, from legal realism, indeterminacy, to law without the state's ends, law and emotions. Emotion number 6, the pleasure of finding things out, and the need for fun, for play. That's fundamentally important. As someone said, innovation needs space to dream, and maybe more importantly, space to make mistakes. Detours and complications create a deeper knowledge and understanding of your topic. If you only repeat what was successful before, you will probably never create something truly unique. Now, why would we take detours, create complications, dream, which, as just suggested, helps? Well, quite possibly for fun. And that might get the world further than many of our other emotional and psychological endeavors. All right, my argument so far has been that if you want to achieve international legal change, it helps to understand how international law changes. And to understand how international law changes, it helps to see that it is also made up of ideas which themselves change. If you want to change international law, one way to go is to change ideas about it. But how does one change ideas about it? How do ideas change anyway? What structures the evolution and production of ideas? What drives us when we think, when we produce scholarship, when we try to produce ideas? What are we really after deep down when we do the thinking work that we do? Well, part of what we are after when we think is emotions, just as when we do anything we do. Identifying what these emotions might be has been my point so far. The next point in the remaining minutes, and it will be quite a bit shorter, will be this. When we produce ideas, part of us is also rational in the sense of, not emotional, in Martha Nussbaum's sense of cool calculation and cost-benefit analysis. It's not a fantastic distinction, but it works for what I try to do. So being rational could, for instance, mean we don't want to shout into the void, call to the ether, even if it soothes our emotions. We want our ideas to be received. One thing that determines whether ideas are received is market opportunities for ideas. It demands for certain ideas. So what structures the market opportunities for ideas? There's quite a bit of literature on the reception of ideas, from Hans-Georg Gadamer on interpretation according to the spirit of the times, to Hans-Robert Jauss on the reception of meaning through history, to Luc Boltanski and Laurent Thévenot on orders of values which stop the regressions of justifications. I'd like to take a more mundane approach. Randall Collins, a famous sociologist of thought, put it simply. He said, market opportunities for ideas open up at particular times, and the times at which these opportunities open up depend on the intellectual network around a person who thinks and its dynamics. So simply put, it is the dynamics of the intellectual network that I'm after. These dynamics, I believe, can be articulated around a typology of factors which influence which ideas will be received, justified, validated in an intellectual network, factors which influence also when that might happen. I believe that the credible typology of these factors might be this: the shifting of paradigms, the rises and falls of schools of thought, the constitution of epistemic subfields, and the shifts in material and ideological interests of the field's important thinkers. Each of these factors has its own likely temporality, its own pace of change. All of them impact the dynamics of the change in thinking, which in turn impacts the dynamics of the object of the thinking, international law in our case. So let me, as I did with emotions, take them in turn. Let me start with paradigm shifts. I mean this in Thomas Kuhn's sense. This is common knowledge, but a 2-minute reminder is in order, I hope, for narrative purposes. During periods of normal science, a field is organized around a central paradigm, a set of ideas, widely shared by the members of the field. Consider in the field of international law the idea that law has to be made by states, that international law must be made by states in order to validly count as international law. An idea that is increasingly doubted in many quarters of the field. And then Kuhn continues, trouble comes to town, as the example just offered suggests. Anomalies appear, situations in which situations in which things are spotted which are not well explained by the paradigm. The validity of the paradigm is questioned, and new candidate theories line up in the competition to become the next paradigm. When the competition starts, the field has entered a period of scientific revolution. The paradigm resists for a time and eventually resigns, allowing a new paradigm to come to the throne and rule the field. A change of paradigm changes what is true and false in the field. It therefore changes the contents of the field. Now, in a field like international law, the field creates the object. All those involved in international law create international law by thinking about it. All noetic unities are created by their field. That's unlike a rock, for instance, which couldn't care less whether we think about it or not. So in such a field, a change in the content of the field, the ideas in the field, means a change in the field's objects, what these ideas construct. International changes if we collectively think differently about it, if we collectively take it to be something else. And we do collectively think differently about it if there's a new paradigm that rules how we think, if the market for ideas in it changes. One might make a parallel here with Michel Foucault's work. Each period in history, he argues, has its own episteme, by which he means its own conditions of truth, which take the form of conditions of discourse. Roughly simplified, what, when, and how you can say something that will be considered true changes from one period to another. When the discourse creates the thing, as in Foucault's work, the idea of madness, the changes in the discourse change the thing. What was considered true in discourses about madness changed throughout history, and therefore what madness effectively was changed throughout history too. It's a social construction. The question is, what are the conditions of that social construction? And by the way, I'm not saying that international is the same thing as madness. Many international lawyers are not mad people. For instance, if there's a paradigm shift or a shift in episteme, so that informal international law counts as international law under the new paradigm or episteme, international law is thereby changed. Change the paradigm or the episteme, change the law, change the paradigm or the episteme, change the market opportunities for ideas. Factor number 2, struggles between competing schools of thought. Kuhn's theory is a bit idealistic. It assumes that a paradigm will, with better analytical purchase, will replace a paradigm with lesser analytical purchase. But paradigms, even if they are pretty bad, can be imposed by brute force. Kuhn himself was used, much in spite of himself, as an icon of the radical student movements of the 1960s. The idea that they are revolutions in scientific knowledge was used as an argument to drive real revolutions against the institutions producing scientific knowledge, the universities. Protests and arsons were used to bring about change in the production of scientific knowledge and thus in scientific knowledge itself. Perhaps scientific knowledge got better thanks to it. Perhaps not. But it changed. And it changed because the power plays changed, because the social forces shifted. Later, Pierre Bourdieu attributed to Kuhn his Marxist insistence on clashes of social forces in his representation of social fields. Kuhn's emphasis on the idea that scientific knowledge is not an immutable objective truth, but rather a matter of changing perspectives, that facilitated the understanding of scientific knowledge as also being the contingent result of social forces. A paradigm may prevail over another because the school of thought built around it is stronger than the other paradigm's school of thought and can thus impose it. Imposition of a paradigm can take the form of an inundation of a field with publications by the school of thought's gangmates, relentless organization of conferences around the paradigm, the launching of an academic journal taking a fitting approach, the impartation through teaching of the exclusive correctness of a particular way of thinking with corresponding grades to follow. It takes the form of intra-law faculty politics in all their grisly violence. the funding of PhD students, of postdocs, appointments of professors, and so on and so forth. Schools of thought have and always will ebb and flow, carrying in their tides the school's paradigms and prefigurations. So came and went the tidal bulges of formalism, constitutionalism, Marxism, the New Haven School, IR theory, the crits, the realists, the empiricists, the Helsinki School, feminist approaches, Twale, legal pluralism, social idealism, law and economics, law and literature, scientometrics, the grid thinkers and the reformists and the perspectivists and the dissociativists and all the others. It is arguably not so different from battles of religions. Different religions provide different competing accounts of the world. Yet the triumph of one over the other is probably due more to power relations than to the accuracy of the accounts of the world. The ideational evolution of international law can be understood through a study of the factors that structure the evolution of religions. There are market opportunities for religious thoughts in the same way that there are market opportunities for international law thoughts. Factor number 3, the constitution of epistemic subfields. When an epistemic field breaks up into new subfields, which means new domains of the practice of thinking, new constructions of the overall common object of study are likely to emerge. The object is likely to become plural. There's a plurality of international law, to acquire a plurality of existences or shapes. Perhaps at some stage in the history of international law, there really was only one worldwide community of people who thought about international law. One worldwide community which shared one paradigm, one epistemology, one set of prefigurations. This would certainly contrast with today's reality, where international law is clearly not the same thing for the different schools of thought I mentioned a minute ago. Formalists, the realists, the Marxists, the critics, and so on and so forth. These are parallel, juxtaposed accounts of what international law is, held in parallel communities of individuals who think about international law, in parallel epistemic subfields. Each subfield recognizes, and by recognizing, creates international law with different shapes. Shifting from one to another is a form of international legal change, because the same phenomenon is each time reconstructed differently, and each time creates a different reality, a different thing that we see. Factor number 4. That's my last one. The shifts in material and ideological interests of the field's important thinkers. What is good for a person is an incentive for that person to see certain things in a certain way, or at least to retain certain accounts of these things. It is in part what is commonly known as selective attention. To put it more precisely for the current discussion, one's interests determine one's epistemology. This power battle in the discipline of international law I mentioned earlier is fought by human beings being partly homo economicus, seeking to maximize their own self-interests. It seems likely that this power battle is fought partly for self-interest, for greed. The intellectual construction of international is a capitalistic field like any other. It too is affected by the incessant drive for the accumulation of capitals of different kinds, not only financial. For a simple example, consider a current or former government lawyer who has interests, psychological interests, making sense of one's life, social interests, belonging to the group of workers, of co-workers at large, and indeed financial interests, staying on good terms for advisory work and other appointments. These are all interests in promoting or sustaining the power of governments. These interests, the pursuit of these capitals, become reasons for an epistemology that prevents the recognition, in my example, of non-state actors as creators of, for instance, customary international law. If one's interests is that governments stay strong, one's epistemology is likely to be that only governments can make law, that only states can create and change international law. These interests are not immutable, and the people who dominate the field are not immutable either. When either of that happens, when either the interests of the influencers, to use that modern word, or the identity of these influencers change to the benefit of individuals with different interests, then international law changes too. The identification of such changes in interests in the relevant individuals is one predictor of international legal change. For instance, academic salaries in certain countries, in many countries, are such that international legal thinkers are led to embrace a certain epistemology. Academic salaries need to remain comparatively low to maintain a state-centric and a business-friendly epistemology of international law. A change in that could cause change in international law. The notion of market opportunities for ideas is taken here to its material conclusion. Who can ideas be sold to? Literally. So what have I done? I've tried to argue that the dynamics of international legal change can be understood by distinguishing three levels of factors of change: the level of formal rules of change, the texts; the level of the social practices creating change, who behaves how and when to do what; and the level of the thinking. International law exists only in our heads, unlike a rock or a table or the computer you are looking at. We make it exist, international law, we make it exist by thinking collectively about it and believing in it. Because of that, how we think about it seems like a relevant question. The level of thinking deserves perhaps as much attention as the texts and the behavior of the different actors of international law. How we think about international law, I've tried to argue, depends partly on emotions. Emotions which guide our thinking, which guides our decisions, conscious or unconscious, to think certain thoughts, to have or pursue or sustain or nurture certain ideas. Emotions of fear, the fear of death and the fear of social rejection. Emotions linked to recognition, to doing what it takes to shine, to be someone, but also the sense of accomplishment that comes from just working hard, and the misplaced moral superiority we may feel as international lawyers. I argue that we should rediscover how not to be serious, to play, to have fun, because it liberates us and pursues no ulterior sidetracking motive. And freedom is good for ideas that can change things. How we think about international law, I have also tried to argue, depends on market opportunities for ideas, the likelihood that there's demand for our ideas and that they will take hold somewhere. These market opportunities, I have suggested, depend on paradigms that structure the field and schools of thought which rise and fall, and the breaking up of the field and thus of international law into different coexisting understandings and therefore realities, and on the very interests of those who think. The paper I delivered today grew out of intermittent exchanges I have had with Pierre Schlag over the last 4 years, in which we lamented scholarship. There's not enough that's edifying or arresting or curious or just strange, as all really new things are strange, and lamented the state of the world. As he puts it in a paper that will be published sometime next year, there's got to be more to life in the academy, more to legal scholarship, more to thinking and ideas in law. There's got to be more. Why isn't there, he's asking? My answer today was, if we'd get to know ourselves better, if we'd remember what we knew about our field a bit more, perhaps we'd understand. And if we'd understand, we might change things, change the thinking, and thereby change the law, as I assumed we wanted. Thank you very much.
Thank you so much, Professor Schultz, for your excellent presentation. We have a couple of questions. So the first one that I would like to put to you is from one of our undergraduate students, Siren Azabi Saim. She has asked, I quote her, as a form of parsimonious theory of legal change, rules take forms of statutes via international courts and other law governing bodies. But for societal and thought changes, who or which body would formalize the said change? How would they be selected? Thank you.
So it's an interesting question. Thank you very much. There is very little formal selection. Everyone thinks, and the thoughts and the understandings of international, of everybody are important. The understandings of international law, what it says, how to interpret it, what counts as international law of soldiers on the ground changes their behavior. That matters. The understandings of judges who apply international law, their understandings are important too. The understandings of diplomats who enter into treaties or who negotiate with other governments, other diplomats, are important too. The understanding of citizens when they interact with international, of what exactly they are interacting with. Do they have a moral obligation to follow that rule because it's a legal rule, or do they not have any moral obligation to follow it because it's just some rule, not law? All of that has an impact on what the law eventually becomes. So it's not formalized. That's maybe the difficulty in studying it.
Thank you. The next question is slightly related to your presentation, not in a way the main theme of your presentation, but in your draft paper, in a way you have presented that we have lots of information, but maybe not a whole lot of ideas or innovative ideas. So is it that you are implying that there is any inverse relationship between the amount of information out there and the gestation of new ideas? Any view on that?
Yes and no. No, in the sense that the overall amount of information does not necessarily prevent new ideas. I would say that because if we forget about international law for a minute, in our world we have much more information today than we had, say, in the Middle Ages or in antiquity. Are we really less creative today than we are in the Middle Ages or antiquity? I don't believe so. I think we are rather more creative. Yes, there's a link between quantity of information and ideas in scholarly production. If you need to cram in as much information as possible before your scholarly production is validated, is accepted, that someone says, oh, this is a good paper, this makes it very difficult for you to have new thoughts. As a PhD student, for instance, a long time ago, I remember people tell me you have to be exhaustive. You have to read everything in the field before you can start to have your own ideas. And of course, the more you read, the more you want it all to figure in your text. You won't read something and then not quote it. You want to reference it. So you end up having to build your narrative by taking into account everything you have read. Possibly, if we read a bit less, we might come to crazier ideas, to more creativity. So how we produce scholarship and how much information there needs to be in our scholarly production, that I think has an inverse relationship with creativity.
Thank you, Thomas. The next question that I would like to put to you is related to the first question that Saira asked. She has asked another question. Her question is, the change in dynamics of international law is determined by the varying ideation of state practice, political conditions, etc. How would the author propose or assess the faction or statistics required to constitute that say change global?
Could you reread the last bit of the...
Sure. So how would the author propose or assess the faction or statistics required to constitute that say change globally?
To constitute that what globally? Sorry, it's last.
That faction that say change globally. I mean, what I understand is, perhaps this is a question about quantity, that there are these dynamics that would influence the change. So I think she is asking that how do we determine that what kind of numbers are needed? I don't think there is any real hard and fast answer to this, but any thought that how will these elements of change somehow bring into fusion that the international law would change? Maybe that's the question, if I have understood her correctly.
If the way I understand, the way I would rephrase it, hoping that I understand it correctly, is how to measure it, how to measure when certain ideas, thoughts are important enough to matter, to change things. It happens to be here, point you to this book. the answer is we shouldn't do it. That book is The Seductions of Quantification. We have a tendency to try to quantify everything. I do some empirical work myself. I'm guilty of that as well. I think in this particular field, I'm not sure it's a good idea to try to quantify how much of a certain thought we need for it to have an impact on anything. Now, if you really want to do that, it's not exactly statistics. There's an emerging field, emerging methods in international called scientometrics, which is using computers, artificial intelligence to measure, for instance, who cites whom, who cites what idea, how do ideas get propagated through a network, what is the size of a network, what kind of people cite one another, forming clusters of knowledge. Then you can see on a map which are the important themes, possibly ideas in a field. It's not exactly statistics. It's something like network analysis, where you can show which people interact with one another around which ideas, which is a way to try to see the impact of a certain idea. Yeah, but that would be my answer to it. Yeah.
Thank you, Thomas. We are almost out of time, so this would be the last question that I'll put to you. This is on the change dynamics in international law vis-a-vis national law, because in international law, we don't have any parliament, we do not have one court with universal jurisdiction all over the world. So do you really see any significant difference in change in international law from change in national law, or the ideas of marketplace for that change, please?
Thank you. I think it's a question of degree, that some of these same dynamics may be at play, some of the same factors may be at play in domestic law and in international law, but the weight, the importance of these different factors will be different, with less institutionalization, with less centralization in international law compared to domestic law. I think the importance of ideas is greater. The importance of how we think about international law can have a greater impact in international than it does in domestic law. There would be more, how to put this, in many ways, I'm going out on a limb here, the social forces are definitely aligned differently. I'm not sure where my thoughts are going now. My answer would be, there's no categorical difference. There's a difference in degree. There's a difference in the relative weight of all the different things which influence international legal change, which, as I try to show, is at least rules and practices and ideas, and all of them can be subdivided into many other categories. All of them play a role in domestic and international law, but the relative weight would be different.
Thank you so much for that answer, and thank you once again for accepting our invitation to deliver this talk. Thank you all. Have a good day.